All right, good morning, everyone. I'd like to start class with a moment of silence for loss of Justice Scalia. This is a very, I'll say a few words, but just for a moment of silence, just think of his memory for a bit. Okay. I'd like to say words about Justice Scalia first before we start class. It's hard to quantify for people who are in law school and who read the laws that exist today how the law existed 30 years ago before a man named Antonin Scalia made it to the Supreme Court. You're only in your second semester of law school, so you probably haven't even read any of his opinions, in fact, maybe a couple. Maybe Connolly read a few. But he's had an effect on the law that's extremely hard to quantify, and I'll give a few main examples. So one of Justice Scalia's first major commitments to the law is what's often known as textualism, the idea that we should look to text to figure out what a statute means. That may seem like an obvious idea to you, but it's obvious in large measure due to Justice Scalia. There was a time in the 1970s where the Supreme Court would say, because the legislative history is inconclusive, we turn to the text of the statute. You'd have lawyers go to the Supreme Court and say, here's what Congress intended, before we even talk about how the text should be understood. Justice Scalia single-handedly changed that. When lawyers came to the Supreme Court and said, here's legislative history, he said, I'm not interested in that. He went out of his way never to cite legislative history. And if he joined a majority opinion, he would dissent for the single sentence where they said legislative history. It got the point across. Justice Scalia's second major contribution is what's known as originalism. Now, he didn't invent it by no means, but he made it that we all have to confront history. Now, what is originalism? Originalism is the idea that we should understand the Constitution and indeed all texts as they were originally understood. This is not about what the framers intended, what their purpose was. What is the meaning of the words at the time they were drafted? Again, this seems so obvious to you, but only because you're living in Antonin Scalia's world. 30 years ago, it was heretical to say we should understand the Constitution by how it was originally understood. It was heretical. You have been laughed out of the classroom. But we see a decision like in 2008, a case called District of Columbia v. Heller, a case involving the Second Amendment. It was a 5-4 decision, no doubt. But the majority opinion by Justice Scalia and the dissenting opinion by Justice John Paul Stevens were all originalist. They disagreed about how the Second Amendment should be understood, but they agreed that the proper methodology was to look to history. Nino won that one. And the third major contribution I think Justice Scalia gave us is the notion that law does not have to be politics. Law does not have to be politics. And Justice Scalia gives a very, very famous example of this, a case from Texas, in fact. So Texas used to have a law in the books that banned flag burning. Banned flag burning. And I think it was at the 1984 Republican National Convention in Dallas. It was 88, maybe off by a couple years. It was 84. There were some protesters who lit a fire at an American flag. And they were prosecuted under this Texas statute for burning the American flag. And the case goes to the Supreme Court. Now, if you were to ask Antonin Scalia as a private citizen, how would you vote in that case, right? Easy, throw the hippie in jail. Throw the scruffy bum in jail, right? But how did Justice Scalia vote? He invalidated the conviction. He said the First Amendment guarantees the right of expression. First Amendment guarantees the right of expression. And this person was absolutely making a political statement, one Scalia strongly disagreed with, but he voted for it. And he would always hold this up as an example. What about in the criminal procedure context, right? You may have studied something called the Confrontation Clause. The idea that if you're charged with a crime, you have to confront your accuser face to face. This is a protection going back to English common law. For decades, the Supreme Court basically ignored it. It said, oh, it doesn't matter. As long as the evidence is reliable, you don't have to actually confront your accuser. And Scalia said no. Even though he probably wanted every one of those criminals to go to jail, he said the Confrontation Clause means what it says, and it says what it means. that you confront your accuser. And in a case called Crawford v. Washington, 2006, Justice Scalia had another originalist opinion saying, no, we need to treat the Confrontation Clause, give these criminal defendants an additional safeguard. So lest be said, Scalia didn't care about people. Well, the Constitution cares about people, and Scalia cared about the Constitution. But beyond anything else, Justice Scalia taught us that you can have a commitment to the rule of law that's greater than any one person. The idea of textualism, originalism, was meant to find what are called neutral principles, way to resolve cases without resorting to your inner preferences. And no theory is perfect. He admitted that. You'll hear in the coming days, well, how do you justify Brown versus Board of Education, right? In 1868, when the 14th Amendment was ratified, there were segregated schools. And what did Scalia say to that? No theory is perfect. But at least he had a theory. It's often said Scalia was unprincipled, right? He didn't follow his principles. He, in this case, deviated. The only reason why you could say Scalia did not follow his principles was because he had principles in the first place, which is more than you can say for most judges. So I've criticized Justice Scalia. I've given my fair share of critiques, and I think he's earned it in a number of justifications. But we as a society are much worse off not having him. Even when he was in dissent, he made the majority stronger, because his dissents forced the majority to confront their own biases and inadequacies. And let me say one more thing about his dissents. He did not write his dissents for his colleagues. He wrote his dissents for every single one of you. He said over and over again, I'm not writing my dissents for today. I am writing my dissents for a future generation not yet born, where maybe, just maybe, the Constitution will be viewed differently. And Scalia often said his greatest enduring legacy was not as a justice, but as a professor. He meant that. He gave a speech to myself and a group of other professors saying, listen, don't forget about your students, right? You can write articles, you can give speeches, but listen, I have all of you as prisoners for about 2 hours a day, twice a week. I admit it. You are here. You have no choice. The ABA forced you to be here. I don't take that duty lightly. I will reach, I've done the math, at 300 students a year. If I have a 40-year career, that's a lot of students. This is how we continue the spark of the law, through the classroom. And Scalia was a professor for many years. He got that. He toured the country. He barnstormed city after city, school after school, teaching students about the Constitution. And frankly, this is something we should all emulate. And I'd like to close with an anecdote of one of my first interactions with Justice Scalia. So I went to law school at George Mason in Washington, D.C. One of the beauties of going to law school in Washington, D.C. is it's very easy to get to events with the justices. So during my, I guess my third year of law school, Justice Scalia just released a book with Brian Garner about how to write well, how to have good legal writing. It's a great book. So he had like a number of book events over the summer, like 4 or 5 book events. Okay, so the first one I bought a copy and he signed it. I was like, okay, that's cool, right? And the second one, okay, I had to buy another copy, signed it, that's cool. So by the third event, I was like, okay, I want to sign my Constitution. So I go to an event, I already bought 2 copies of the book, I don't want to buy another one. So I go to the event, and I say, I have my little, there's a Cato Constitution, just like this one, right? And I say, Justice Scalia, would you please sign my Constitution? He goes, get away. Shoot me away. Don't worry, it gets better. I tried again. I go to a lot of these events, you can tell. I say, Justice Scalia, would you sign my Constitution? He says, no, go away, scram. Okay, I took a hint. So then, about a month later, Justice Thomas was coming to my law school. He was giving a lecture. One of my professors was a Thomas clerk, and I said, Justice Thomas, would you like to sign my Constitution? He's like, of course. So he signs it. So then I went to a 4th Scalia event, and I said, Justice Scalia, will you sign my Constitution? And he said, go away. And I said, well, Justice Thomas signed it. Justice Thomas signed it. He says, all right, give it to me. And he scribbled his signature and I was like, get lost. He was a great man. He was hilarious. He made everyone laugh. He brought so much joy to the bench. If you read the statements from the justice, Justice Breyer said the court will be a much more gray place. Justice Ginsburg and he were good friends. She said he was my best buddy. They traveled together. There's this great picture of them riding an elephant together. So lest you think you can't get along with people you disagree with, look no further than Antonin Scalia and Ruth Bader Ginsburg. They were the best of friends. we've suffered a momentous loss at an inopportune time, and none of us saw this one coming. So I realize it's a property class, but you'll read some of these cases next semester in Property 2, and you will read cases in Common Law, but we are all worse off. And I have my photo album here with this is me and Scalia. This is me as a law student. You come and look after if you want. This is me with Justice Thomas when I got the other thing signed. So you can come back to class and look at these things. But I need to get this framed now. I've been lazy, but I'll do it eventually. So that's my story. Anyone want to add anything about Justice Scalia or anything like that? Any thoughts? Anything in your minds? It's very sad. Very, very sad. Okay. Nothing? All right. If any of you want to talk to me after class, I'll be around. Okay. So property. Okay. So the midterm was yesterday. From what I heard from Ashley, things for the most part went okay. A couple of you came in late. Don't do that. You realize if you're late for the bar exam, you don't get to take it. If you're 1 minute late for the bar exam, you fail. If you're 1 minute late for a court hearing, your client defaults judgment and you lose. This is not a joke. Okay, this is not something you can just flub. Also, I mean, a couple of you sent me frantic emails about not being able to use the word count. You can always do a manual word counting with your finger, right? You're going to have technical problems as an attorney. The filing won't work. You can't print this or that. These aren't excuses. And frankly, not being able to use the word count software, you know how to do arithmetic. You can add, right? You're all, in law students. You graduate college. I'm assuming you know how to add 1,000 words. The instructions are on the front page if I use the word count. So, actually, the registrar only gave me the exams last night, so I haven't had a chance to look at any of them yet. But I will shortly. But a couple of you sent me these frantic emails. Also, one other note, don't send me frantic emails. The reason why is it betrays the blind grading, right? The entire purpose of the blind grading is I don't know who you are. But if you send me an email saying, I wrote 4,000 words for the first question, I know who you are. I mean, I may not remember, and I'll do my best to scrub it from my memory, but if you give me a very specific problem, it's hard for me not to. Now, for the midterm, it's not that big of a deal. But for the final exam, don't send frantic emails. If you have a question, send it to the registrar. Even worse, if you have an emergency that you can't come to class, don't email me because I can't do anything about it. Because the second you say, I didn't take the exam, I know there's a late submission, I know it's yours, right? Don't do stuff that betrays the blind grading because I can't help you. And the worst part is, students send me these emails, I don't reply, and they freak out more and send me 5 more emails saying, why didn't you reply to my email? Don't email me. Email the registrar. They are, or go to them. They're right on the 2nd floor, across from the library entrance. They know how to do with these things. They'll contact me in a discreet manner. I don't want to know if you have problems because I know who you are, and that betrays a blind grading, which I take very seriously. That's why I said put your number on your exam, not your name. I don't want to know who you are. It's really for the best. All right. So any general, not substantive questions of the exam. I'll do a review at some point. I don't know when, but any procedural questions. Yes, that's Sarah, right? I
did finally figure out how to do the word count, but it was different than the instructions you gave.
Okay.
And so I guess those that need to figure it out, we can talk about it later.
Yeah, I mean, now you know. Another reason why I do the midterm is now you have a dry run. But I mean, seriously, in the event that you have a technical problem, you can 1, 2, 3, 4, 5. I mean, I've done it myself. It takes about 2-3 minutes. It's not that lengthy to do. And actually, for the midterm, I give a fairly short question. It's only about a page and a half. It was one I did deliberately to give you more time to prepare and read. But yes, but I thank you. I mean, the software, they updated it, so maybe my instructions were off. But I appreciate the suggestion. Anything else? Not substance. We'll go over the substance at some other point. Once I've had a chance to look at your papers and see what you got and what you didn't get. Yes, sir. That's Jamie.
Just generally, when do you expect to be able to get those back?
I don't know yet. I'll tell you when I know. I'll do it as quickly as I can. I have about 80 of you in this class and about 85 in my other class, and that's a lot of papers to read. But I will do my best to read them as quickly as I can. I just got them yesterday. I haven't had a chance to open the files yet. Anything else? No? No one need the sheet? Okay. All right, so let's move on to today's lesson, which talks about gifting. So today's topic is the last topic in acquiring possession. In class starting, I guess, let's say Thursday, so I guess class starting next week on Tuesday, we'll be starting a new topic. And I'll just make a note. The readings for Tuesday look deceptively short. You are almost certainly going to have to read at least 2 or 3 times. I'm warning you. This is probably the most earth-shattering lesson you'll have in the entire class. It's only a few pages. It's not a lot. Read it twice. Make sure you get it, because the stuff we're doing today is common sense, like hunting foxes and giving gifts and rings. The stuff we do next week becomes very abstract. So, but the stuff today is something which you've all been, exposed to, which is gifts. Giving something to someone. Now, notice this is not selling it with payment. This is gifting without payment. The reason why I drew this distinction is because there are an entire different set of laws for selling something and for gifting something. In fact, you've already done the selling stuff, which is contracts, right? UCC, restatement. There's entire articles concerning the selling of objects for payment. But gifting is a slightly different story because it's actually based on property law. Okay? So before we begin, I want to go over terminology. So I always like to make our terminology clear. So these are 2 words which you almost certainly have seen at some point, but you've never really thought much of it. Donor and donee. Not donut, donee, right? These are the 2 parties involved in a gift. Now, I have no idea. Where did I finish up last time? Wow, good memory. That's Daniel, right? I was going that way, right? It's going that way. Okay, thank you. Saved by the bell, right? So Daniel, I want you to try and take a guess, right? One of these is the person who receives the gift. One of these is the person who gives the gift. Which is which? Okay. How do you know that? Exactly, right? When it ends in EE, that means you're receiving something. And then the other one is the giver. So you have the donor and the donee. Everyone okay with that? We'll come back to this over. There's the grantor, grantee, mortgagor, mortgagee. You'll see this over and over again. It's the exact same concept. All right, so thank you, Daniel. So in order to give a gift, okay, 2 things, actually 3 things, must be present. Okay, Cesar, what are the 3 things that must be present in order to give a gift? Okay, right. So first is intent. Okay, good. What's the second one? Delivery. Okay, good. And what's the third one? Thank you. Okay. 3 elements. It's not very often in this class I'll say there's 3 elements to X. This is actually a rarity. Students love elements. This is actually one of the rare instances, right? But generally speaking, there are 3 elements for a gift. Right? So for example, if I just go over here, right, and I leave my cup here, and she takes it. Who is that? Is that Madison? I left her cup there. Whenever I'm walking past teaching class, and she takes it. Is that a gift? Is that a gift? Right. There was delivery. I put it on her desk. Acceptance. She grabbed it, right? But I had no intent of actually giving it to her. So usually the most important aspect of this topic is trying to figure out the donor intent. Did I actually intend to give it to her, or is this merely, putting a piece of property down? Okay. Intent is almost always based on oral evidence. It does not have to be written. Remember the Statute of Frauds? You say that in contracts? You burned to have your memories, right? You can give a gift without having anything written. Your intent can be oral. Okay. The second act, delivery, proves to be somewhat complicated, right? So if I put this cup down, I certainly evinced, I showed an act of giving. So Rachel, why is the act of delivery The second component is so important. What's so significant about delivery?
Depends on what your delivery means.
No. In the abstract, why is delivery such an important element of a gift? Let me ask a question. What if I say, look, I'm going to give Jacqueline this cup, okay? Jacqueline, I'm going to give you this cup, okay? I leave it here. But I just said, Jacqueline, I'm giving you this cup. What's the problem? I put it right here.
The delivery doesn't match with the intent.
Oh. But what happens if, Jacqueline comes and says, wait a minute, yesterday Josh told me he wanted to give me the cup. He never gave it to me. Do we believe her? Exactly. The act of delivery is the evidence of the intent, right? She can lie all day. She can say, Josh said it. I'm like, I never said that. But the actual act of delivery is proof certain, right? If I say, Jacqueline, I'm giving you this cup, delivery, boom, she has it. It's in her possession. This is the old lesson we've had about certainty in the law, right? Efficiency. What is the most efficient way of giving a gift? Handing it to the person, because that way it's an evidentiary issue. There's no dispute. There's no doubt that I gave her the present. And indeed, this is actually a preview of next class. But there's an old tradition, which you probably read about in the notes here. What the hell is this? Called livery of Seisin. It's Livery of Seisin. Seisin. And back in the old times, back in the times of feudalism, people were illiterate. People did not know how to write. Okay? And if people don't know how to write and engage in legal transactions, Fanny, if people don't know how to write and engage in legal transactions, what do you think was the most effective way of showing that a piece of land was being transferred? They're illiterate. They can't write. Yeah. So what's the physical action of transferring the land? How do you hand to them a huge farm? Like, how do you do that?
Well, in this instance, they take a piece of turf.
Yeah.
Literally exchange it. For
Yeah.
shilling.
You will remember nothing from this class except for this video, okay? You'll watch this video. I bet students come back and say, man, that video, I remember it. This shows what livery of Seisin is. Let me play it. It's a few minutes.
Broker IPTV. Today we're talking with Michael Robinson from Robinson & Henry Law Practitioners. Michael, welcome to the show. Thanks for being with us.
Glad to be here.
We had you on a previous segment, and we were talking about deeds and the different types of deeds. We went through the standard 6, but at the end, we started talking about a very old method in which they used to transfer property, and it was called livery of Seisin. Is that
It
correct?
sure is, and that's where the word deed actually comes from, is that action.
All right, real quick, what is livery of Seisin recap?
Because most people were illiterate in England at the time this thing developed, they would bring witnesses out to the property, and witnesses would be able to witness the buyer giving money, the seller giving over the actual physical parts of the property, namely turf and twig, which is the two things that it's called a turf and twig ceremony.
All right, so for a first time ever on Broker IPTV, we'll do a reenactment here.
I think it's an
All
excellent
right,
idea.
so what we're going to do is we're in Old England, and we're going to transfer property. And of course, we have to dress the part. Now, am I the buyer or the seller?
You are the buyer.
And you're selling me this land.
Yes, and we've come out here with two witnesses
Okay.
to watch
All right.
all this happening.
And how does this procedure go?
Okay, you're going to start by cutting out a piece of turf on the property.
All right, so we'll just...
And you hold on to that turf.
I hold on the turf, okay?
Now, put money in the hole.
All right, I got some cash. How about a buck for this?
Buck
Will
is
this
works
work?
here. It's a couple shillings back in Old England.
Okay.
Okay, and then hand me the sod.
This piece?
Yes, you do.
Okay.
And I take the twig,
Yes.
and I take the sod, and I say this following: This turf and twig I give to thee, as free as Athelstan gave to me, and I hope a loving brother that will be. And I twiggle you with the twig.
Really?
Yes, I do. And then I put it in the sod, and I hand it to you.
Thank you.
And then you take the sod and put it back in the hole.
All right.
And with that, you just bought this wonderful property.
And I've been twiggled.
Yes, you have.
Wow.
And the reason for that was so that blind people could still buy and sell property, even if they couldn't see what was going on. They knew that they were at least getting the twig, and they knew that they were getting the property.
Well, that's a heck of a lot easier than the 3-hour closing today.
Yeah. In Pennsylvania, the entire state of Pennsylvania was purchased exactly this way by William Penn.
Really?
Yes. And there's a statue of him in Delaware, actually, which is across the river from Pennsylvania, where he actually did this turf and twig ceremony.
All right, last but not least, could this be recorded?
Yes, and that's actually what happened was at a later time when we started moving more towards recording of deeds, they would get the witnesses and they would get them to sign an affidavit saying that they had done this particular thing and that they had witnessed that this happened. They witness an action. They witness a deed occurring. You did a deed.
Yes.
Or I did a deed by giving it to you. And that's actually where the word deed comes from. And all the other deeds that we have today. And this thing, and most of this stuff, if you think about it, still exists today in modern real estate. When you go to a closing, there are other witnesses, one of which is the notary public. And almost always when you go to a closing at the end, the buyer hands the keys to the seller, which is the...
Well, I'm going to twiggle my buyer at my next closing. Michael, thanks so much for the information. I appreciate it.
All right, so you'll read more about livery sizing later when we do real estate transactions, but the history and the reason why we have this component of delivery is so it's clear to the world that I am giving this cup to her. Right? There's no dispute. Okay, any questions on intent or delivery? It gets more complicated. We'll do questions in a couple minutes, but that's the general gist of it. Okay. The third element, and originally I said there are only two, is almost always presumed. And what do I mean by that? If I intend to give a gift to someone, and I actually hand it to the person, generally, as the saying goes, you don't look a gift horse in the mouth, right? You don't turn down free stuff. Occasionally, maybe you want to turn down free stuff. You don't have to maintain it or whatever else. You don't like the person, so it's presumed. So unless there's actually evidence that person, no, I reject this. So for example, say your mother gives you a birthday present of a beat up old car, right? It's like, I don't want that, Mom. Get rid of it. Okay, you've rejected it. But if you say nothing, it's presumed that now you own the land or now you own the car. This often happens with, say, someone says, "Oh, I want to give you this piece of real estate. It's a great piece of real estate." It's like, "Oh, thanks, Mom." And then it turns out there's property taxes on it, and there's condo fees on it, and there's all these assessments. So you're actually losing money by taking this gift off your mom's hand. So you can reject a gift. Okay. Now, any questions on that? Okay. Now, it's not always possible. I mean, I use the example of the cup because it's easy. I can put this on her desk fairly simply. But it's not always possible to use actual delivery because things are heavy. Right? Things are big. It's not always feasible to transport it. So there are two alternate approaches to delivery, right? There's actual delivery, there's constructive delivery, and there's what's called symbolic delivery. So there's really three methods, right? The easiest one, actual, I hand it to her, no question. So, Karima, can you explain to me what constructive delivery means?
So constructive is basically if the donor thinks the zoning that a tree or something that essentially the donor no longer has control or dominion over the property.
Very good. By the way, has anyone, Karima, you're good. Do you remember the word constructive in any of your other classes that you've taken in law school so far? Maybe in Civ Pro? Anyone know what I'm thinking of? Did you service a process? You remember what constructive service a process is? Oh, yeah. Remember what it is?
Like you couldn't really serve the person directly, so
Yeah.
you had to maybe post something in the newspaper.
Yes, I remember that right from Civ Pro, right? The word constructive in the law is used in many different contexts, right? Constructive means not actual. So if you can't reach a person by physical service, actual service or process, you can put a thing in the newspaper, right? You can post it in the post office, right? There are different statutes in different states that permit these sorts of things. So constructive delivery is just that. You can't actually deliver it. It's physically impossible to hand it over. So you give something to represent it. And the example the book gives is like a key, right? You can't hand over a huge, dresser, because, this thing's like it's humongous. So you hand over a key, which can be used to open it. Okay? Now, everyone loves ideas. Like, yeah, that's great. Hand over a key. But is that Samuel?
Yes.
Samuel, tell me, please, what is the risk of not requiring actual delivery? What's the risk?
Sometimes something could be included in the piece of property.
Oh, that's good, but I'm thinking more basic. What's the general risk when you don't have a situation where the donor hands the item to the donee?
You don't have the evidence of the actual piece of property.
I'm sorry, say it again?
You don't have the evidence of the property.
And when you don't have evidence, what does that create the possibility for?
That there wasn't an actual.
And what do we call that? When someone takes something that wasn't really theirs?
Theft.
Fraud. Yeah, you're exactly right. Fraud. Almost everything we'll be discussing today in class are rules meant to minimize the risk of fraud. Right? When I say, Jacqueline, I'm giving you this cup, I put it here, I hand it to her hand, no one in the world will dispute that I intended to give this cup to Jacqueline. No one. But the example that Samuel mentioned, I give you a key to a dresser, right? Well, okay, maybe that means I'm giving you the dresser, but what about the life insurance policy inside of it? There's issues of doubt. There's a possibility for fraud. That perhaps the true heirs of this old man, we'll do in a few minutes, were supposed to get the life insurance policy, not the other woman, right? So when you have this when you have this constructive delivery, there's a risk of fraud. Okay, so under the common law, where again people were illiterate, they couldn't write. Under the common law, they disfavor constructive delivery. They disfavored it because it opened up the potential for fraud. Under the more modern trend, courts, as we'll see throughout the semester, become much more liberal, and they're willing to accept alternate forms of delivery, including constructive delivery. Right? So the trend has been going from not liking constructive delivery towards, in the modern sense, embracing it. Any questions on constructive delivery? No? That's Adam?
Yep.
Adam, what about symbolic delivery? It's a slightly different standard.
So as opposed to constructive, where you're going to hand over a key or something that gives you access to a piece of property,
Okay.
symbolic delivery is just handing over something like a piece of paper.
Yeah, right. So symbolic delivery is actually, again, fairly recent. We now have people who are literate. They can write. They can draft a document saying, I want to give you this pen, right? I want to give you this cup. Right? It's some sort of legal instrument or some sort of piece of paper. Okay. But again, Thomas, what's the risk then of allowing symbolic delivery?
The
Same risk.
same risk is
What's the risk?
fraud.
Yeah. The same risk is there as fraud, right? What the document was forged. We don't know. So under the common law, again, the simplest way is I hand you this cup. There's no dispute in giving you this cup. But once you go to things like keys, a piece of paper that actually forged, because it's not the actual item. So I want you to keep in mind for the remainder of class the potential for fraud and how it informed the common law rules. Whereas the modern approach, we have computers, we have word processors, we can develop documents to have chain of title and make things a little bit easier. Any questions on the symbolic delivery? By the way, someone always asks me this. Symbolic and constructive blur together. In a couple minutes, we'll go through examples. They blur together very closely. So don't ask me, what's the difference? There's not much of a difference, right? You can do a key as symbolic. You can do a piece of paper as constructive. They really blur together. There's not significant difference. So don't get hung up on which is which. Okay. So let's do some questions first. If you turn to page 190 in your book, please. There are a number of problems. And we haven't had too many of these yet, but throughout the semester, I do like to do these sorts of questions in class. So as you're doing your reading, don't just skip over the notes, as I'm sure most of you do. Actually try to entertain a guess, because I very well may call on you in class to answer it. So, okay, so is that Nancy? Just read question number 1. Just start reading problem number 1. Okay, so stop right there, okay? So O has a ring, right? O is the owner of the ring. She leaves the ring, Nancy, on the counter. She just, slips out of her hand, whatever, right? She's washing her hands. At that moment, Nancy, by the way, the reason why the mother is called O, this will blow your mind. She's the owner. Every single example you'll see in this book, the owner is called O. I didn't realize that until about 6 months into law school. Okay, I'm serious. I only got realized in my second semester in law school. O is the owner, and invariably the first person to get it is called A, and the second person to get it is called B, and the third person is called C. This will help you immeasurably as you read through these cases. So, Nancy, did the owner, when she put a ring on the sink, have any intent to give a gift? Exactly. Okay. So at the moment she put the ring on the sink, she had no intent. Okay, keep reading, please. Okay, stop right there. So when A takes the ring in her hands, how would you characterize that action? I'm not talking about intent, but when A takes the ring, how would you characterize that action? What comes prior to acceptance? Delivery. So this is the example I gave with Jacqueline a couple minutes ago, right? I leave my cup here, and I walk away. She says, oh, Josh wants to give me his cup, so she takes it, puts it in her hand. There's delivery, and there's acceptance. But there was no intent. So at this stage, and I keep interrupting Nancy every 5 words, at this stage, there was delivery, there was acceptance, but there was no intent. Okay? Nancy, please keep reading. What do we call it when someone says, I want to give you this gift? Okay. So finish the sentence. Finish the paragraph. Keep reading. Okay, so Nancy. Sorry, I meant finish the next sentence. I'm sorry. I'm being mean to you. Thank you. You're doing a very good job reading it. Was there a gift from the owner O to A at this point? Why was there a gift? Do they have to be satisfied in order? That's the insight. All 3 elements are present, right? There was delivery, there was acceptance, and then after that, there was an intent to give. The insight here is you do not need all 3 elements to be sequential. And this one always throws students for a loop. They're all there. All 3 elements are there. So, for example, use the example 4. I go here. I leave this cup here. Jacqueline takes it. Hey, Josh, you forgot your cup. Like, oh, you can keep it. Gift. It's hers. Now her cup. Now, so Lois, let me ask you the question. Not Lois. I'm sorry. Lola. Sorry. Let's go close. Lola. I'm trying to get the name. I'm 5 feet away from the chart, so you can see it. So Lola, let me ask this question. So I leave the cup there. Jacqueline takes it. I say, you know what, Jacqueline, you can keep it. What if the next day I change my mind? Like, no, I don't really like her. So I come back and take it. Can I do that? Can you revoke a gift? Why can't you revoke a gift?
Well, all 3 elements were satisfied, so it was a gift.
Who now owns it?
She owned
I have nothing to it, right? So the final, the final question, which I cut Nancy off rudely, was, can O the next day require to return it? The answer is absolutely not. The answer is absolutely not. Once you give a gift, it's permanent. It's irrevocable. You cannot return. I mean, Jacqueline can give it back to me if she so chooses, but I have no future claim to the ring, or ring or the cup or whatever it happens to be. Everyone get that concept? A little tricky, but not that hard. Okay, Camille, please, can you start reading the second paragraph where it says suppose?
Suppose that A does not show a sense of the fact that the ring is found. A week later, at a dinner with friends, A surprises O by producing the ring. O takes the ring, looks at it, then gives it back to A, saying, I want you to have it.
Okay, stop right there. What do we call that, right? So when O gives her the ring and says, I want you to have it, what just transpired? And there was intent. What else was there? Delivery, and what else? Yeah, a gift. O said, I want you to have it. Here, take the ring. A takes it, she puts it on her finger, right? But it's too big. Okay, so I'll move on to the next one. Samantha, what happens after A tries it on, it's too big? Keep reading.
Owen says, let me wear it until you can get it cut down to fit you.
Okay, so A hands the ring back to O. Is that a gift?
If that, hands it back to, well,
What?
gives it back to her mother, then yes.
What is the intent when A gives it back to O? Is it a gift for permanency?
No, just to get it resized.
What do we call that? If you remember from last week, where you give something to someone to hold on to for some period of time. What's that word?
Bailment.
Bailment. Bailment. She's a bailee. It's not a gift. It's a bailment. She's saying, hold on to this. I'm going to get it, fixed, whatever. It's not a permanent gift. Yes, Hunter.
How is preparing the ring not a rejection if she can't wear it?
Well, actually, the second she accepts it, the gift is finalized. Because read the thing carefully, right? She gives her the ring, puts it on her finger. That's acceptance. And then even if a second later she gives it back to her, the gift was already made. The second you have that delivery and the acceptance, done. You can't undo that. Okay? So then I'll go to Norma. Norma, please. So then it says, O leaves the dinner, tragically, is struck by a car and killed. In this class, people die very suddenly and violently. The reason why is that's how property changes hands. People suddenly die. So I promise you in the final exam, lots of people die sudden, painful deaths. I've had questions at like the rodeo. I mean, they die in random ways, but they have to die. The reason why, because in this class, we don't actually do how to transfer property during life. Basically, for the most part, property is transferred after death. So not for the faint of heart. So Norma, the mother dies in this tragic car accident, right? And then A tries to get the ring back from the executor. What happens there?
She's gonna fix the version of the ring and that her mother gave her a future interest for it.
Whoa, good answer. What's a future interest?
Basically,
I'm reading it. Good.
basically it's like the mother intended to give the ring to her, even though she didn't provide the delivery, the actual delivery. Her intent, it was kind of like an oral type of intent, but there were obviously, I think there were witnesses to that.
Good.
So
Good. Yeah, so this is the idea of a bailment, and I'll talk about futurists in a couple minutes. You're like 5 minutes after that. We'll get there, I promise. But this is the idea of a bailment. The daughter only gave it to the mom to hold on to temporarily to get it resized. It was not a gift. So when the mother dies, the ring comes back to the daughter because it was never the mother's in the first place. The mother's heirs do not have any future interest to it, which is what Norma was alluding to. I'll get to futurists in a couple minutes. Okay. Everyone see that? There's a funny note involving Bill Kraft, who's the owner of the New England Patriots. Everyone read that. So there was, the New England Patriots have won a number of Super Bowls over the last decade, and there was one scene where the owner of the Patriots met Vladimir Putin, who at the time was the I think he was a president at that point of Russia. He's now the prime minister again. And Putin asked to see the ring, so Kraft handed him the ring, and then Putin said something like, "I can kill someone with this ring," and then he put it in his pocket. And Putin was sworn by these KGB guys. By the way, the KGB is long gone, but Putin was a KGB agent, so it's fitting. And he walked away with the ring. So was there actually a gift? Well, there was definitely delivery. There was definitely acceptance. I don't think there was intent to actually give. However, afterwards, Kraft, on the nudging of the U.S. State Department, released a statement saying, "I decided to give President Putin the ring as a symbol of the respect and admiration that I have for the Russian people and his leadership." So here we have a situation where there was delivery, acceptance, and then a couple months later, intent. Therefore, the ring is Putin's. He will wear it with his shirtless pony rides and whatever else his scuba diving. I mean, the cult of personality is fascinating. They actually have these feats of strength for him, where they have these animals that are wounded and they can hunt them, and they have these fish that are maimed so that they can go after them quicker. He discovered all these buried treasure that were planted. I mean, it's remarkable how the cult of personality works. Okay, that's Amala. Go to the third paragraph, please, which says, "Suppose that at a dinner."
Can I read it?
Yes, please.
Suppose that at the dinner was, O had not said the words quoted, but instead said, "I promise to leave you this ring when I die." What result?
Okay, thank you. Stop there. So I need to explain to you a concept which the book like only hints at, which is tragic. So has anyone ever had a situation where a loved one or a family member passed away and that person had a will? No one ever had a situation? Okay. So generally speaking, after a person who has a will dies, there's a process called probate, where there's a judge who actually reads through the person's will and ensures that the property in the person's, person's estate is distributed in the manner in which the person wants. And the reason why this probate process is so important is because the opportunities for fraud are so great. The person is dead, right? Grandpa's dead, grandma's dead. He can't come back and say, no, I didn't want that person to get it. I wanted this person to get it. This is why having a very precise will is done to ensure that the person's wishes, the person's intent is fulfilled. And as a tool to prevent fraud, something called the Statute of Wills. You'll take an entire class in wills and trusts. I'm giving you just 5 minutes about this now. The Statute of Wills is designed to make sure that when a person decides how to distribute their property after death, they do so in a manner that's verified. They do so in a manner that resists fraud. So the key, so just like the Statute of Frauds, right? The Statute of Frauds says any transaction for sale of whatever must be in writing. So too the Statute of Wills must be in writing, right? You can't have an oral will. I mean, there are rare cases where you can, but for 99% of the cases, you cannot have an oral will. The will has to be in writing and signed by 2 witnesses. Why would a will be signed by 2 witnesses? To prevent fraud. You can imagine, right, if, some guy is on his deathbed and, his evil, stepdaughter, puts a paper in his hand saying, Daddy signed this, whatever, right? He doesn't even know what he's reading. He's incapacitated. Is that a valid will? No. Or it's, hey, my grandpa signed this will on his deathbed. Okay, did anyone else observe it? Were there any witnesses to the situation? No? Garbage. Okay? So the key fact is when you want to leave property after your death, your will must comply with the Statute of Wills. 2 independent witnesses. And there's a phrase I'd like you to know called testamentary gift. Testamentary gift means a gift that takes place after death, right? If I say, when I die, I want to leave you my farm. When I die, I want to leave you, my house, whatever it is. A testamentary gift that takes place after death must comply with the Statute of Wills. And again, the reason why is obvious. The dead person is no longer around to come to court and say, wait a minute, that's not what I meant. That you're getting it's all wrong. These are meant to ensure the person's last wishes are honestly and faithfully executed. Okay? Everyone get that with me so far? Yes, Trail.
So with testamentary gifts, I'm thinking like life estate and testamentary gifts.
Oh, you're going way too far ahead.
Well, I just have a quick question. Does the creditor get those first?
We're gonna do that like the next couple weeks. You're like 4 classes ahead. You're on the right track, but you're way ahead. I'll get there, I promise. So everyone just get the general gist. If it's a gift that takes place, oh, I'm sorry, yes, sir.
I just had a question on the Statute of Wills. Yes. You say 2 independent witnesses. Is there anything in place to prevent like a husband and wife visiting the 2 witnesses to avoid fraud?
I don't think so. I mean, it may vary by state. But I think family members can be witnesses just fine.
I mean, like, so grandpa's daughter and her husband.
Evil people, right?
Yeah.
I mean, I think that varies by fraud, varies by state, but very often the witnesses will be the family members, those people helping the person draft the will. But the key fact is it's done well in advance, and that they actually swear an oath that the person who signed the will was of good mind and good mental state. And you can always challenge later, saying, well, if the guy was in a coma and his evil stepdaughter and her husband was a fraud, so you can challenge on other grounds. But this is a preliminary guard against fraud. That makes sense? And you'll take a full class in wills and trusts. I don't want to bore you with this, but this is all you need to know for this class. So then a testamentary gift, right, is what happens when you comply with the Statute of Wills, right? So say what happens if you only have one witness on your will, or maybe the witness was fraud, right? Maybe the witness signed the wrong name, or maybe the witness, wasn't who he said he was. Maybe the witness was actually, the evil stepdaughter and she's trying to be someone else. Okay. If a person then dies with a bad will or no will, they died intestate. Okay. They die with a bad will or no will. It's called dying intestate. You'll do this in other classes. When a person dies with no will, it's called dying intestate. And at that point, the state decides how to chop up their property. And there are all these complicated rules you'll study. The wife gets a certain share, the children get a certain share, the grandchildren get a certain share, and it goes down. It's actually fairly rigorous formulas. I don't expect you to know these. Okay? They die intestate. So these are all gifts that take place after death. There's a different kind of gift called inter vivos. Don't worry, I'm going to come back to your promise eventually. It's a little backfilling. I think you're on edge waiting to be called on again. I'll get back to you in a second. An inter vivos gift means a gift during life. Right? Testamentary means a gift after death. Inter vivos means a gift during life. Okay. Why is this relevant? A gift during life does not need to satisfy the Statute of Wills. A gift during life does not need to satisfy the Statute of Wills. Okay. Now, Amal, I'll ask you the question here. Why do you think if I'm giving you a gift during life, we don't have to worry about the Statute of Wills and witnesses?
Is it because of the three elements?
Let me ask you a question, right? I give you this cup, right? Like on the whole thing. I give you the cup, right? Mm-hmm. And then the next day say, wait, no, I never gave her the cup. What happens in court then? If you have the cup one day and say, no, I never really gave it, she took it from me. What can I do? I can say something. Why can I still say something? Because I'm alive.
Yeah.
With an inter vivos gift, I'm still alive. And if there's a dispute, I can go and challenge her. Right? I can sue her in court saying she took it from me. Inter vivos means, like vivo alive. It's during life. I can challenge it. So the risk of fraud is much less. Why? Because I'm still around to contest it. Whereas a testamentary gift, I'm dead. I'm in the great beyond, and I cannot contest it. It's actually an interesting question. Speaking of Justice Scalia, it's unclear what he did with his papers as a justice. Every justice decides what to do with their papers and records independently. And from what I can tell and gather, he hadn't made up his mind yet. So at this point, his papers likely go to his heirs, who can release them, burn them, do whatever they want. So that will be an interesting thing to watch in terms of papers. Okay, so I'm going to get the difference between testamentary and inter vivos. You'll see this more clearly in the case of the painting, because there's actually a dispute over whether it was a gift during life or a gift after life. The book doesn't even explain that, which drives me nuts. So that's why I do this first. So Ryan, please finish reading question number, the third paragraph that Amala started 5 minutes ago. Suppose that at the dinner above, O had not said,
I promise to leave you when you die.
No, stop right there. Okay. So it says, she had said, I promise to leave you this ring when I die. What kind of gift is that? Is that testamentary or inter vivos?
That is testamentary.
Why is it testamentary?
Because she would
You're right.
A would receive it upon the death of.
Exactly. It was a gift after death. Everyone see that? It's a testamentary gift. Okay. So Arusa, was that a valid testamentary gift? She just said, I will give it to you after I die. That's it. Was that a valid testamentary gift?
I think so, just because there are witnesses there.
Was there any writing? Did any witnesses sign? It was a valid gift? No. This is why the Statute of Wills is important. It's not enough that there were people at the dinner table with them, right? You need witnesses to sign. And you need witnesses to sign it in writing that they understand the circumstances. You can't just scribble on the back of a napkin a will. I mean, there are cases where someone's about to die where those may be actually upheld, but for the most part, you cannot do this orally. Okay. Any other questions on that? Yes, sir. That's hold on. That's George.
How would you change the wording to make it ambiguous?
You tell me. It's really easy, actually.
I'm giving this ring now, but I want to hold on to it until I die.
Well, that's the facts of the Pinky case. What if she just said, "I'm giving you this ring now," and she didn't hand it to her? Would that be a valid gift? Think of your three elements.
There's no delivery.
Exactly. In order to have a present gift, there must be delivery. And if I say, "I'm going to give you this ring," and I don't hand it to you, there's no delivery because it's not a good gift. Now, why do you think, right? It's a Hunter? No, that's Hunter. That's hold on. That's a Pierce. Pierce.
Yes.
Pierce. Why do you think that most people won't simply say, "I want to give you this ring now" to make things easier? Why do people say, "I want to give you something after you die"?
Because they like it and they're still attached to it.
Yeah.
It's a good gesture.
Who wants to give up their stuff during life? This is why people leave stuff after they die, right? You give up your house before you die. What if your kid throws you out? Because once you give the gift up, it's not yours anymore. You want the ring. That's why people leave stuff after their death. They're attached to it. We'll do a case later this semester where there's an old couple, and I think their son or daughter is taking care of them, right? And say, "Okay, I'm going to leave you this house after I die," right? Why do they just give it to them now? Well, once they give them, they can stop taking care of grandma and throw them out because it's yours. Do whatever you wish. Yes, Marissa.
Wouldn't it also be like the tax purposes?
Yeah, there's tax reasons I don't really care about for this class, but yeah, the things about gift taxing, when that's what the Pinky case alluded to, but I don't really care about the gift tax here. But yes, there are certain incentives to do it early. So the next paragraph, paragraph 4, discusses engagement rings, and this is actually a fairly complicated area of the law, and I put a couple recent examples involving celebrities who were engaged with extremely expensive rings, and what happened? There's actually a lot of money, so there was actually a situation. I think it was Britney Spears was engaged to this guy Jason Trowick, and Britney Spears returned the ring. In contrast, one day I won't have to mention my class, but eventually that day's night arrived. Kim Kardashian, who was married to NBA star Chris Humphries for about 72 days, refused to return a $2 million ring to him. And then he was saying it was a 20-carat diamond. And he was saying, "I don't understand why she won't give it back. What does it matter to her?" And I will not even offer you a response what I think about that. But the law is actually fairly interesting in this. Historically, wedding rings were deemed conditional gifts that were given from the usually man to the woman, as it were, on the condition that they actually get married. And courts actually looked at who was the cause of the breakup. So if the guy was the cause of the breakup, courts traditionally said, "Okay, the girl can keep it." But if the girl was the cause of the breakup, that means she would have to give it back because effectively she violated the promise, right? There was a gift given on the condition that they were to get married. But once they are indeed married, that's it. You don't have to give it back, which is why Kardashian was under no obligation. They, in fact, were married. I think it was annulled, but I think she went through the celebrity TV act of going through the ceremony. And there are a number of states that have called heart bomb laws, which basically mean let the girl keep it because we feel bad for her. Where they don't even draw this distinction.
Will the same thing happen?
Yes, sir. Shane. Yeah.
I'm sorry.
Yeah.
Will the same thing happen if they got engaged and one of them died? Would the estate be able to reflect?
There's a case. I think we'll do this in a class in a couple weeks. But there's actually a case where man and woman at the altar. The priest says, "Do you take this, man to be?" Yeah, I do. And like the moment after he says, "I do," he dropped dead. We'll do this case. I can't remember the exact facts, but it's in a couple weeks. And the question was, did in fact the marriage occur? And was there actually now going to be a division of assets? Once you're married, you divide assets. The guy had some property or whatever. And the court effectively said, once you say "I do," and then you drop dead, you're married. So the short answer is yes. Once you're married, you're married. Till death do you part. Literally, I mean, literally, till death did them part. Crazy, right? Okay, that'll be the last Kardashian reference of the semester, I think. I hope so. All right, any other questions? I hope I come to a day where I won't have to mention this in class, but eventually I can still somewhat see it. Yes? He didn't say, "Will you marry me?" So it's just like a Valentine's Day present?
No, like one knee.
Oh, so you're parsing his word.
You take the ring, you say, "Thank you for the ring." No, I will not.
I'll answer the question, right? So I think the question is, the intent of the donor was that he was giving the ring on one knee with the expectation that it was a proposal. If the other person did not see it as such, I suppose a court could litigate whether in fact it was a valid marriage proposal. Right? This wasn't just a "Happy Valentine's Day, honey" gift, right? This was an actual on your knee, bachelor style, giving her the rose. But I suspect the court would say she would have to get the ring back, but one can never know. Let me know if it happens to anyone. I don't know. Any other questions? Yes, sir.
Do they still look at? Because I know you mentioned it, but do they look at still the guy's to blame? The girl keeps the ring.
That was a common law rule, though I suspect that rule is somewhat on the wane. Yeah. Probably more often than not benefiting the guy, so that rule's probably on the wane. Diamonds are forever, I suppose. So, 2 months salary. Right? Okay, so any questions? All right, let's do the first case. Let's go back here. Lauren, please. What were the facts in Newman versus Bost, please?
Okay, Newman, she was the housekeeper for
Was she just the housekeeper?
She was also
Yeah. So we have a situation here. Hold on. How old was he? He was really old. Yeah. Okay. So there was like a 50-year gap or 40-year gap between the two of them. Thank you, Lauren. So what happened was, Mr. Van Pelt was a fairly distinguished gentleman. He had a big business. He was the mayor of his town, and his wife had died 10 years earlier. And then he had this poor orphan, Newman, come to be his housekeeper, and they fell in love. It's the classic telenovela, right? So, she's taking care of him in more ways than one, and we get to the point where, he's on his deathbed, quite literally. And he calls for his nurse, and he calls for his, his girlfriend. And he does some stuff, right? There's no writing, so we don't have a Statute of Wills case, right? There's nothing in writing. So, Florencio, tell me, please, what does Mr. Van Pelt do? How does he just stick to it? What does he actually do?
He points to the.
He points, right?
Right. He points to
to
the chest or the insurance safe.
Right.
And then he hands her the key.
Okay, good. So we'll break down. So Florencio, you're exactly right. So he points for this huge dresser, right? These huge pieces of furniture. He points to it, and inside there's actually a life insurance policy for $3,000, and he hands her the key, which we use to open up the dresser. Okay. Let's see. Carlos, what does he do next? After he points to the dresser, what happens next?
He says that she wanted him to come.
No, I'm not saying what you said. What did he? He's pointing. What else is he pointing to?
Oh, and other rooms.
Exactly. Thank you, Carlos. Yeah. So after he points to the dresser, He starts pointing to all the furniture in the room, and he starts pointing to the other household property, you know, and you know, he says, you know, this is all yours, right? It's vague and unsure what he actually said, because again, the only people there were the housekeeper and the nurse, right? We don't have anything in writing, so it's based on speculation, right? So we have then a situation where we don't have anything in writing. The old man, after he does his pointing job, he falls into a coma, whatever, he dies, he can't speak anymore, and we don't actually know what his intent is. So he dies. This is Miss Newman, the girlfriend slash nurse or housekeeper, comes in and says, "Hey, heirs of so-and-so, I'm sorry your dad's dead, but he gave me all your stuff." You can imagine how this conversation went. He's like, "Yeah, I'm sorry your daddy's dead, but you know, I get everything." And they were like, "Go away." So she does what everyone does in this class, is she files a lawsuit in court. So Sarah, in order for Mrs. Newman to state her claim, what must she establish? What must she demonstrate?
The elements of the giving of the gift.
Yes, ma'am.
So intent, delivery, and acceptance.
Okay, so let's break this down one at a time. The issues, the court jumbles together the issues, right? Let's talk first about the dresser with the insurance policy, Sarah. How does Mrs. Newman explain that she gets not only the dresser, but the $3,000 policy inside of it?
She said that the reason he handed over not the keys and said you get the dresser was to say when you unlock that, what is in there is
Good.
yours.
And what do we call that sort of a delivery? What kind would that be?
Do you mean like intervivos or no?
Well, no, it's testamentary for sure because after death. But what kind of delivery is that where he hands her a key? What do we call that?
Oh, I see. Constructive.
Thank you. Yes, I think the book maybe calls it symbolic, but they're the same thing. They're interchangeable, so don't get hung up on that. So it's constructive or symbolic delivery, and the reason why I think is somewhat obvious, right? The guy's on his deathbed. He can't like lift this massive thing and like say here, right? He can't just give it to her. So perhaps giving her the key was the method, but was it right? Is that Jose? Jose, please tell me. Short of giving her the key, what else could he have done to demonstrate they wanted to have the policy itself?
He could have told her, please go in there.
Yeah.
And bring me that.
Wouldn't that have been easy enough? He's like, okay, here's the key. Go open the door for me. Take out the policy. I'll put it in your hand. I'll twiggle you, right? Oh, I don't know what they were doing, but you know, he could have demonstrated this in a much more real manner. And I think this is why the court didn't rule for her in favor of the will. They said, listen, 30 seconds more, she could have opened the door of the dresser, taken out the thing, and handed her the policy. The fact that they didn't do it says, no, maybe he just wanted to have the dresser, right? So you know, sucks to her. She gets a piece of furniture when she wanted the life insurance policy inside. Also, I think the insurance policy had beneficiaries on it. Usually you designate on the actual policy itself who gets it when you die. So I think there was some conflicting intent, which is why they probably didn't give it to her. One phrase they use in the opinion is called let me write this to you guys. I can't speak Latin today. Justice Scalia's father was a Romance language professor. He knew Latin fluently, so he could say this much better than me. But donatio causa mortis, which basically means a gift in intention of death or a gift in anticipation of death. This is your classic deathbed confessional where you're about to die. You don't have to write stuff down, right? But there's a risk here, right? Jeremy, what's the risk of courts giving effect to these deathbed gifts? Hard to prove, exactly right. Thank you. Because who do you have? The only witnesses are the woman who stands to gain and her friend, the nurse, right? You don't have any independent witnesses in writing. So for all we know, she took the key from his dresser. Right? I mean, we don't know how scrupulous this person is. She could have just taken the key from his dresser and said, oh, it was mine. He was pointing, right? Making stuff up. We don't know. So the courts are very skeptical of these sorts of gifts. And the opinion in this case basically says, listen, we now have, like, we're not in Roman times where people were illiterate, right? People can read today. They can write. They can write something under the Statute of Frauds. They can write something under the Statute of Wills. There are means of giving gifts. This guy was an intelligent guy. He ran a business. He knew how to do stuff. There were means by which he could have given this gift on his deathbed, short of this pointing, gesticulating, uncertainty. So the court will strictly construe this doctrine of causa mortis. They're not going to suggest that we will read it more broadly to try to give stuff where there's not clear evidence. Okay. So unfortunately for Mrs. Newman, she gets the furniture, but not the thing inside. Had he actually handed her the policy itself, I think the case would come out quite differently. So questions on the first case? Yes, sir.
So it doesn't really come up, but in the opinion they speak about him being paralyzed. I'm just wondering, if you are paralyzed, how do you ever transfer a gift?
Well, if he had told her, please take out the policy, I think that would have been enough. If he'd actually referenced the policy itself, even if he was paralyzed, I think that would have been effective means. Even if he can't hand it to her, telling her, okay, go take the policy and put it in your hands and keep it with you. Right? Then there would have been evidence that she actually had it. As was the facts here, is the children of the deceased guy had it. Yes, sir.
The beneficiary still control?
Not if it's a gift. See, this is the key point, right? Before you die, you can revoke a prior gift. The entire point of the insurance policy is, I will give you this after I die. There was no present intent to give it. You can revoke that at any time before your death and issue a new will, a new policy. It wasn't actually gifted to the children yet.
One thing that I guess that kind of had me confused was, if someone gives you a house, and let's say it was constructive delivery or symbolic or whatever, everything in that house, arguably, wouldn't you say is yours if they gave you the whole house?
Not necessarily.
So even though it would be included in the thing,
it's not something called a fixture, right? So if you ever go to a house, there's like a bookshelf built into the wall. That's part of the property. It's called a fixture. That's actually belongs to the house. Furniture like a couch or a TV or a table, that's not actually part of the house. And even if someone gave you constructive delivery of the house, the personal property would go to the heirs because it's not physically attached to the land. We'll do this topic later. It's called a fixture. Something's actually literally built, like, the sink is built into the into the house. That saves for the house. You can't rip the sink out when you leave.
so in this case, the court literally differentiated the drawer by itself
From the
as
furniture.
opposed from everything else that's inside of it.
Yes, sir. Yes, sir. Any other questions on the first case? Okay, let's go into the second case. The second case is interesting. It actually involves a famous painting by an artist named Gustav Klimt. And anyone see the movie The Woman in Gold? I didn't like it. The book was much better. But it involved this painting of a Jewish woman in Austria. Her name was Adele Bloch-Bauer. And during the Holocaust, it was seized from this Jewish family in Austria. And there was this lengthy battle to try to recover it that went all the way to the US Supreme Court because it was basically stolen from this family, and the heirs of this family finally recovered it in a lengthy battle. But here we have a case where there was a father who was very wealthy, and he had this painting by Klimt. And for his son's 21st birthday, he wrote a letter. First letter said, "Son, I give you this present, which I own." But then he sent the second letter saying, "Wait a minute. My lawyers told me to not send that first letter, so go ahead and burn that letter. Send it back to me, I'll burn it." The second letter said, "Once I die, you get this picture." Okay? Once I die, you get this picture. But I'm actually giving you to today. Huh? I'm giving you this picture today, but you get it after I die. How can this be? Up to here, Jonathan. How can this be? I'm giving you this present today, this painting, but you get it after I die. How can this be?
I think it relates back to when she mentioned the future interest.
Yes, you guys are reading ahead. Good. What does that mean, future interest?
Yeah, he's retaining possession, but in writing he put, like before he made it while he was alive, saying, "When I die, you will get this gift." So doesn't that make it valid?
Okay, so let me ask you this follow-up question, Jonathan. The three elements of the gift, right? There's intent, there's delivery, and acceptance, right? Was there delivery during the life of the father?
Symbolic. Oh.
Whoa. Was there delivery?
It was an actual delivery.
Was the letter a symbolic delivery?
I think so.
Couldn't you actually deliver a painting? Is that so hard?
Yes, you could have.
So, Jessica, let me ask you this question. What was the father's intent when he wrote the second letter? Not the first letter, when he wrote the second letter. What was his intent? Describe it for me, please.
Not to pay the taxes.
No. He's trying. Yeah. He's trying to dodge. Let's not worry about taxes in this class. He was trying to dodge taxes for sure. What was his intent with the second letter?
He still wanted for the son to have evidence that he had the intent to give.
Give it when? When was the gift going to take place? This is the tricky part. When was the gift to take place, Jessica?
I could consider that it was present intent
When would he actually get the painting?
at death.
Okay, good. Serenity. What did I say a couple minutes ago? What do we call a gift that takes effect after death? Yes, ma'am. A testamentary gift. Exactly right. And Serenity, follow-up question. What must a testamentary gift comply with? Yes, ma'am. And that requires how many witnesses? Are there any witnesses on this letter? So is this a valid testamentary gift? Exactly right. And this is what the stepmother argues, right? The stepmother argues this was not a valid testamentary gift. It was not a valid testamentary gift. And she's right about that. It's not a valid testamentary gift. So, Bianca, because it's not a valid testamentary gift, what kind of gift must it be? There are only two types. Yes, ma'am. Inter vivos. So again, what are the three elements of an inter vivos gift? We've done this whole class. Good. Was there delivery here during the life of the father? Was there acceptance during the life of the father? What was the intent then of the father when he wrote these letters? Okay, exactly. So I want to introduce you to a concept that will make more sense next week. And again, I think Drael and Jonathan alluded to it. But when we speak, I've mentioned before, when we speak about property, I'm not just talking about who owns it. There are two questions, right? Who owns it and when do they own it? Okay. When you look at a property question from PR and out in this class, you have to ask yourself who owns it and when do they own it? And I gave you an example last week where I said, maybe you're leasing the property today and your lease rounds up in February, and then your friend has a lease from February to the next year, and then someone else has a lease for the third year, right? You all have a stake to that apartment, but at different points in time. And there's absolutely nothing wrong with that. So we speak of the bundle of sticks, right? Remember our favorite bundle of sticks? The bundle of sticks is not just about the right to exclude, the right to include. It also refers to different time periods. So imagine this blue marker says, okay, the father will have it during his life. And this black market says, well, whatever's left over or after the father dies goes to the son. Right? So you put them together. The painting is a bundle by itself. The painting's a bundle by itself. The father has it for his life, and the son gets it after life. There's nothing wrong with that. Property doesn't disappear when someone dies. Property must go somewhere. Property cannot be unowned. It's actually an interesting principle. Property cannot be unowned. There's no such thing as unowned property. The second it comes into your contact, it's yours. You can't get rid of it unless someone accepts it. So what this case represents, and it's a little complicated when you read it the first time, is that even with an inter vivos gift, you can assign what's called a future interest. All right, this is the word that JL and Jonathan used before. You have a present interest, and you have a future interest. 90% of the class will be on what are called future interests. These will drive you mad, but we'll keep it easy for today. The father keeps a present interest. And if you want to be fancy, it's called a life estate. His present interest is he has it during his life. If you don't understand this, that's fine. We'll come back to it next week. But the present saying, listen, I'm keeping this for my life. The son has a future interest. Sorry, this should say a father. I meant to say father. Son has a future interest. It's what's called a remainder. Okay? So a bundle of sticks. The father's a life estate. The son has everything else, the remainder. Once the father dies, everything goes to the son. This is not complicated, right? I'm sure you've all inherited property from your mother, your grandmother, whoever it happens to be. But the reason why this is tricky, and the reason why the lower court split on this, we'll go down here to Lily. Lily, what was the father's intent when he wrote that second and third letter? What was he giving the son? What was it?
The future.
Yes, exactly. When the father wrote the letter, he was not giving him his present interest, his blue marker. He was giving him his future interest, the black marker. He had an intent to give a future interest. This is the hardest part of the case. He had an intent to give a future interest. So Brian, let me ask you a few questions, right? I answered the first one already. What was the father's intent when he gave him this letter? What was he giving him?
Future interest.
Was there delivery of this future interest?
I guess it would have. The delivery would occur when he dies.
No, that's wrong. When do you give someone a future interest, during life or during death? Brian, I'm asking a question. When do you give a future interest?
Oh, sorry. By the letter in this case. So when you.
The letter. Why didn't he actually give him the painting when he turned 21?
Because he wanted to hold on to it.
No. In order to give someone a future interest, you actually have to give them the actual object now?
No, you can hold it.
Why would it not make sense to give him the entire painting if he's only getting a future interest? Why would it not make sense if you're only giving a future interest to give him the entire painting now?
Because he's wanting to still.
Yes. The father retains the present interest. It would make no sense to give the son the painting if all he has is a future interest. Let me say it again. It would make no sense to require the delivery of the actual painting because the son doesn't get it till later. What represents the future interest is the letter. What represents the future interest is the letter. That is the delivery. That is the constructive or symbolic delivery of the future interest. The only way you can give a future interest is in writing. If you give the son the actual painting now, that defeats the purpose to you. There's an actual delivery. It's a present gift. Okay, I'll get to you a second. Does everyone get that point? So in his 21st birthday, the letter says, I intend to give you this painting in the future. The letter is the constructive delivery of that, and the son accepted and held on to the letter. Therefore, there was a valid inter vivos gift for a future interest, right? There's a valid inter vivos gift for a future interest, if you want to say it straight out, right? There was an intent to give future interest first. There was constructive delivery by the letter. And there was acceptance when the son kept the letter. Done. Valid inter vivos gift.
Isn't that a really good way to avoid the statute of wills? Because
Yes.
you really go up to someone that you actually want to basically be the bad person.
Why do you think his lawyers advised him this way?
Because they didn't want to deal with the statute of wills.
Yes, sir. So the dirty little secret is, and you'll do this when we do wills and trusts, most people with any assets don't write wills. They write trusts. And what a trust effectively says is, while I'm still alive, I will deposit all of my property in this account. And when I die, it goes to someone else, but it does not go through the will process. You basically give someone a present estate. So, for example, we'll do, you may have heard the expression of a trust fund, right? A trust fund. Okay, what does that actually mean? Rather than, Conrad Hilton leaving Paris Hilton billions of dollars during her life, Conrad Hilton will give a fund of $1 billion to a person. Say, listen, you have to manage Paris Hilton's inheritance. Every year after the age of 21, give her a certain amount of money. You don't give all the money at once. You don't wait till after death, but you designate someone, and that avoids all these various gift taxes. So sophisticated people don't actually use wills. They use trusts. And this is effectively a method of the trust, and the father, in fact, is a trustee. He's holding the property for the benefit of his son. Don't look at it that way. The father is holding the property for the benefit of his son, because once the father dies, it's his. Now, the father can't renege on this, right? He can't then decide to, oh, no, I'm going to give my other son this when I die. He's already given his son a valid gift, which is enforceable in court, right? Had the father subsequently said, you know what, when I die, I want to give it to my wife, invalid. Invalid. because he's already given away his future interest. All he has left is the life estate. Yes, ma'am.
Okay, so I thought you said it was part remainder. I thought it was only whatever.
The son gets the remainder. Yeah.
The remainder interest when dad passes away.
Yes.
So if he sells a portion of the interest.
He can sell his present. He can sell his life estate, right? He can say, you know what? Yes. And then once the father dies, it goes to whoever's the remainder. We'll spend a lot of time on remainders. Don't get too much into this now. Yes, Crystal.
Yeah, I thought I had an understanding about this one part of the case that I think is wrong now. But like with bundle of sticks, I was thinking that they were talking about that you can have possession and then you can have ownership. And I thought it was saying that there was present interest that he gave him and that was ownership. I thought it was saying that they said, I'm now giving you ownership and that's present interest, but I'm going to keep it. That's.
Try to think of in terms of these two questions, right? And again, this is going to be 90% of our class. Ask yourself who owns it and when do they own it. Ask yourself who has the present interest, who has the future interest. In this case, the father has a present interest. He has it for life. It's called life estate. And the son has a future interest. It's what's called a remainder. So after the father dies, everything left over goes to the son. The son has it in entirety. He owns the painting in its entirety. That make sense? No?
It makes sense. I just was I still didn't understand that part of it with possession and.
Think of it this way. The terminology gets confusing, which is why I like the bundle of sticks metaphor. Because at any given point, different people may have present interests and different people may have future interests. And what we'll be doing for the next 6 or 7 weeks is in every single case tracking who has a present interest and who has a future interest. So in the end, the son got the painting, and he sold it for a lot of money, and it was sold again for even more money. So the lawyers advising the father gave him pretty good advice. Okay. Any questions on the first case or the second case? All right. For Tuesday, read it very carefully. I'm telling you, read it twice. You'll be blown away, but read it twice. Thank you so much. Have a nice weekend.